morning everyone, whilst you all join. I think we've got about 40 or so participants today, so I'll just wait for the numbers to get up to that and then we'll start.
Okay.
Grab something. Okay guys, I can see the chat, so I can keep an eye on that. Okay, it's about 11:05, so I think I'm going to make a start because we want to try and wrap this up by 12. So first of all, I'd really like to thank Scott and Kenzie for inviting us to present to you all today. If you have any questions during the webinar as we're going through, then please use the chat facility and we will try and answer them either during the webinar or if not, if we run out of any time, then we'll send an email to Scott with our answers. So insolvency is a real issue facing the construction industry today, as I'm sure many of you are aware. But surprisingly, a recent article in Construction News that I read the other day noted that insolvencies in 2020 were actually 40% down on 2019, which is surprising given the unprecedented impact of COVID last year. However, the article then went on to state that the reason for this is that since April 2020, the construction sector accounted for 17% of all coronavirus business interruption loans and bounce back loans, and it also benefited to the tune of many billions for self-employed furlough and support schemes. Sadly, the government bailout won't last forever, and Construction News has also reported that following a survey undertaken by the Office for National Statistics earlier this year, where it spoke to 3,500 construction firms, 1 in 8 of those questioned has little or no confidence that they will survive beyond April this year. Some quite stark figures. And the reality is that COVID and to a certain extent Brexit has had a dramatic impact on the UK economy and in particular the construction sector. And I think that these statistics are sadly likely to become a reality for many in our industry over the coming months. So this webinar that we've been asked to present today, I think comes at a time when AMG Bailey may well have to deal, if it's not already, with insolvency issues in its supply chain and in the very near future. I want to emphasise that our seminar today is not intended to be a technical seminar on insolvency practices and procedures. When I introduce the rest of the group, you'll see that we're all construction lawyers as opposed to insolvency practitioners. But what we wanted to do today is to consider what insolvency means to a main contractor such as AMG Bailey and what it can do to protect itself against the impact of subcontractor insolvency on its projects. So I myself, I'm Justine Brazil. I'm a partner in the construction and engineering team at Spencer West. Before joining Spencer West, I've worked in-house for a number of years, including at Wilmot Dixon, Mace and Keir. I'd now like to hand over to Liz Vago, who can tell you a little bit about herself.
Hi, thank you, Justine. So I joined Spencer West probably just over a year ago. My background's mainly in large infrastructure projects and renewable energy. I've also worked in private practice for quite some time and then subsequently in-house for contractors such as Balfour Beatty Investments Limited. Perhaps I can hand over to Nigel next to introduce himself.
Good morning, everybody. So, I'm Nigel Croxford. Yeah, I'm actually not a lawyer, though I do have a legal qualification. In my background, I joined Spencer West in November 2019 to work in the construction engineering team to help with dispute resolution. But I've got qualifications in health and safety. I've spent most of my working life in construction project management as a project manager and as a construction director, over 20 years as construction director. So I've probably seen quite a few problems over the years that I hope he can share with you. And I pass over to Jonathan.
Hi there. Yeah. So I joined Spencer West towards the end of last year from Fenwick Elliott, where I'd been for 5 years. And before that, I'd been in the in-house sector, principally TfL and Crossrail and Jacobs Engineering for 8 years, having come down from Scotland, working private practice before that. So more recently, a lot of my experience is rail and infrastructure, which obviously has a lot of MEP input. But throughout my construction career in dealing with disputes, principally, I've dealt with everything from heavy civils down to resi developments. So covered the full kind of spectrum of dispute work.
Great, thanks very much, everyone. So there are a few other members of our team, and just so in case you're wondering, the other Spencer West LLP Zoom person on this is our colleague Louise, who is running the seminar in the background for us. So the rest of the team, we also have Antoine West, who is the West in Spencer West. He is the managing partner and co-founder of the business, and he himself is also a construction and engineering lawyer. Nick Harrier is a partner in the construction and engineering team, and he specialises primarily in disputes. Frances Yvonne is a partner in our team, and she also specialises in investment, multi-sector projects, international trade, renewable energy, oil and gas, and is currently based in Ghana. And then we also have Shan Greer, who is a partner in our team, specialising in infrastructure projects, disputes and alternative dispute resolution. Shan is a partner who is based in St Lucia in the Caribbean. And then finally, Sarah Evans, who's about to join us. Her first day with us is on Monday. I bet she's looking forward to that. And she's a new partner that joins us from Charles Russell Speechlys, and again is specialising in construction, engineering, energy and infrastructure projects. Okay, so let me get into insolvency and the purpose of our webinar this morning. So the agenda for today, we are going to look at what exactly is insolvency, what does it mean? The Corporate Insolvency and Governance Act 2020, which came in to force last year, and what impact that has had on insolvency practices. How do the main standard form construction and engineering contracts deal with insolvency? What to look out for with regards to risks and issues at pre-contract stage, and what you can do to protect yourself, particularly practical steps and also legal and contractual protections before you actually get into contract with your subcontractors. Then post-contract, so when you've got the contract up and running, obviously this is a time when a subcontractor could potentially go into insolvency, and it's things to look out for and what you should be aware of to try and avoid getting yourself into trouble. And then signs that the subcontractor may be in trouble, and steps to take in the event of suspected insolvency. And then finally, if unfortunately the worst has happened, the subby has gone insolvent, what should you be doing at that point? And then at the end, if there are questions to be answered, we'll try and pick those up at the end. Okay, I'm going to start off then this morning and hand over to Liz, who's going to talk to us about what actually is insolvency.
Thanks, Justine. So as many of you may know, but insolvency is, or corporate insolvency is governed by the Insolvency Act 1986. And really, in a nutshell, there isn't a definition as such for insolvency, but what the Act does refer to is it uses the phrase unable to pay its debts. So it's basically where a company is unable to pay its debts. And there are several criteria for establishing whether or not a company is unable to pay its debts. This is set out in section 123 of the Insolvency Act. And those criteria consist of the following. If a company fails to pay a statutory demand for a debt of over £750, or if it fails to satisfy enforcement of a judgment debt, or if it doesn't pass what's called the cash flow test. So that basically means that the company's unable to pay its debts as they fall due. And then you've also got something which is called the balance sheet test, and that's where the court's satisfied that the liabilities of the company exceed the assets of the company. So those are basically the criteria that you'd look at to establish whether a company is unable to pay its debts. And then just moving on to insolvency procedures, you basically, the insolvency procedures that you'll come across fall more or less into two categories. There are those procedures that are concerned with or allow the rescue of a company as a going concern. And then you've got procedures that are really concerned with the cessation of a business, realizing the assets and then returning monies to creditors. So just very sort of briefly, procedures such as administration are there to allow a company to remain in business. And that's really falls into the first category, i.e. one where it's concerned with the rescue of a business rather than winding it up. I'm not going to spend too much time going into that, into these processes. I'm just going to sort of basically outline them. So administration would be the most common one you come across. And then you've got liquidation or winding up, which falls into the second category, which is basically concerned with liquidating or winding up a company, collecting and selling the company's assets, which then you sort of get the cash out of the business and return it to its creditors. So I'm probably not going to say much more about those insolvency procedures, and I'll move on to the next slide, Justine. If anybody's got any questions, I think, Justine, did you say that, put it in the chat box? Yeah. I think you're on mute.
Yes, yeah, if you can use the chat box, that would be great. Yeah. I'll click on it.
Okay. So just moving on to the Corporate Insolvency and Governance Act 2020. I mean, this has been a really key piece of legislation because it's probably it's sort of overhauled or introduced changes to the Insolvency Act 1986. So the largest raft of changes really since the Enterprise Act of 2003, and it's really addressing a number of things. It's bringing in changes that have been in the pipeline for some time, but then it's also bringing in changes to address what's happened due to COVID-19. So it introduces permanent changes and temporary changes. And the temporary changes are largely there to address the impacts of COVID-19. So in terms of the permanent reforms, it's brought in basically three changes. So it's introduced a new moratorium on enforcement action, a new restructuring plan process, and then particularly key for the construction industry and of interest to you guys will be the disapplication of supplier termination of contract provisions for insolvency. I'll come on and talk about that in a bit more detail. And the temporary changes that have been introduced, so they're listed there on the slide, but as you can see, there's suspension of the wrongful trading regime, which will now fall away 30th of April 2021. Then you've got the suspension of the serving of statutory demands and winding up petitions where the company's in financial difficulties and are attributable to COVID-19. That's been extended until the 31st of March 2021. So again, I'm not going to spend too much time explaining what these particular procedures are because there's a lot of detail around there. So I think, Justine, if you can just click on to the next slide, I think, yeah, I'll talk a little bit more about the disapplication of supplier termination because that's the one that impacts construction contracts here is probably of most interest to you guys. So how do the standard forms deal with insolvency? Well, if we look at the JCT contract and the NEC, which are probably the most common ones that you'll come across, clause 8.1 traditionally allows for automatic termination if either the employer or the contractor becomes insolvent. And NEC 4 also contains provisions around either party's ability to terminate the contract if either party becomes insolvent. Now, the JCT or neither contract really defines insolvency, but they do set out the scenarios or what constitutes insolvency. And it's namely either party entering into the insolvency procedures. I'll just mention here actually the fact that something to be aware of is, as I alluded to earlier, is because there are now some new procedures that have been introduced, what has been in the JCT and NEC, the definition of insolvency procedures will now be expanded to include the new processes that have been introduced by the Corporate Insolvency and Governance Act. So that will include restructuring plans and moratoriums that have been introduced under the Act.
Liz, can I just interrupt? We've got one question that's come up. I wonder
Yeah.
if you or any of the other panelists can answer. If a subcontractor was in an administration phase and was subsequently rescued, would this be reflected in a financial credit report in the future? Does it stay on the record?
I don't know that. I don't know if anybody else knows that. Do you mean financial? You mean when we're doing credit checks, presumably, if it shows up on the Dun and Bradstreet reports, I guess they're talking about, aren't they? Is what? Yes. Okay, you've said yes there. I don't know, to be honest. We can certainly find out and come back to you. I personally don't know. I don't know whether any of the other panelists know the answer to that question.
I would have thought it's the nature of the way it's been rescued. If somebody's come in and funded the company, if it's gone into some form of, well, it's in administration, yes, I think it would be on the record. But if it didn't get to that stage, it wouldn't. I don't think it would show. But I think certainly in an administration phase, it would show up on the credit report because it's obviously legal action that's taken place.
Yeah, I agree with that. It would obviously depend on the route into administration because things obviously like CCJs, etc., will show up, and general changes in credit situations. So I would agree with that.
Great, thank you.
So just sort of finishing off on that slide. So as it stood, either party can terminate if the other party enters into insolvency proceedings. But things have changed, and I think, Justine, if you just move on to the next slide. So this is the important bit, really. Since the introduction of the Corporate Insolvency and Governance Act, one of the key changes, and it's permanent, is the disapplication of the supplier right to terminate if, and this is key, it's the employer, it will be the employer under the construction contract, enters into an insolvency procedure, bearing in mind that the insolvency procedure will now include the new procedures that have been introduced under the SEGA Act. So what's important to remember here is that it doesn't apply to the supplier. So if the supplier becomes insolvent, if you're taking a construction contract, then the employer can still terminate the contract if the supplier enters into insolvency proceedings. The supplier doesn't have that right or the automatic right to terminate the construction contract if the employer becomes insolvent. So I think that's key for today. Of course, there are other effects of the SEGA Act, but I think that's pretty important in the context of construction contracts. There are exceptions, however, and those exceptions, so for example, if you're a small supplier, then it doesn't apply. Now, the exemption for the small supplier will fall away at the end of this month. So at the end of this month, those small suppliers will still be subject to this. There are also instances where the supplier can terminate if the employer enters into insolvency proceedings, and that's where the liquidator or administrator consents to it, or the employer itself. Then it will be able to terminate the contract. Also, if it's shown to cause the supplier financial hardship, then it will also be able to terminate the contract in those instances. But I think Jonathan's going to come on and talk about other remedies such as suspension, so the interface with the Construction Act. So it doesn't mean that that's it, the supplier is now not able to do anything. There are other routes that it can take, but I think Jonathan might be addressing some of those next. I'm happy to go on and answer questions, by the way, because I'm conscious that I've sort of gone quite quickly through some of this stuff. But if I hand over to Jonathan, I think Jonathan, Justine, is going to talk to the next slide and pick up some of these. Okay. Oh, sorry, not Jonathan. Is it not?
Justine? Yeah, it's me. It's me in the next. Me in the next slide. Can you go back? Just go back one, Justine, because Liz, although Liz covered some of it, there were other points that I wanted to raise there. So yeah, I mean the key about this act is that we're obviously looking at it from a construction perspective, but it doesn't just apply to construction. It applies to all contracts for the supply of goods other than financial services. Thankfully, Liz did cover the exceptions, which I was just actually trying to quickly look up before I spoke there, so that's good. I don't have to deal with that. But the main thing I want to deal with on this slide is okay, it does apply to construction contracts, but construction contracts, of course, have their own act, what we commonly term the Construction Act, born in 1996 and amended in 2013. But there is an issue. I think there's always been a tension between insolvency statutes and the construction statutes when it comes to things like adjudication and enforcement of adjudication. There has been recent case law which tidied all of that up, where one of the judges said he didn't believe there had ever been any tension between the Construction Act and the Insolvency Acts. But that belies everything that I've discussed or heard or discussed with other people since the Construction Act came into play. Most people have thought there has been a tension. And I think that this new act creates a further significant tension between the rights that parties have under a construction contract under the Act, that's compliant with the Act, and this new Insolvency Act. And that comes down to, okay, so there's a prohibition on termination downstream, i.e. you can't terminate the person who is supplying goods and services can't terminate the person that they're supplying to if they become insolvent. But if a party becomes insolvent, what happens? They stop paying. And what does that mean in the context of the Construction Act? Well, the context of the Construction Act, which is replicated in most construction contracts, is if you don't get paid, you've got a right to suspend works. And suspend works until suspend your obligations under the contract, which by and large means the works, and you're allowed to do that until you're paid again. So if a company has gone insolvent, it's unlikely to pay you again. Therefore, it's a de facto termination in a sense, which would be against the wording of the implicit wording of the new Insolvency Act, but in line with the wording of the Construction Act. So what's the answer? Well, you might think that part of the answer is in the phrase, you can't terminate the contract or do any other thing. And you might argue, therefore, that suspending the works in the event of non-payment is doing any other thing. Now, what would normally happen in situations like this is that if there was a conflict such as this in interpretation, because doing any other thing does not reference any previous legislation, it doesn't explicitly refer to the Construction Act, it doesn't explicitly carve it out, it doesn't specifically include it. So what would normally happen is the later act would take precedence over the earlier act when you come to points of interpretation like this. But in those circumstances, you would usually have to be implied from the wording of the later act that the previous act has in effect been repealed on this point. And my view is that the wording any other thing is not sufficiently clear such that it excludes or precludes the right of a party to suspend their obligations under the contract if they're not paid. Now, as far as a search of case law on the SIGA 2020 Act has gone when I did this yesterday and this morning, I can't see any cases yet which specifically deal with this issue. So in theory, my view is at the moment that you would still have a right to suspend works in the event of non-payment under the Act, but there are risks to that, because if that's viewed as an unlawful suspension of works due to the later Insolvency Act, then you will be found, if they make the argument, to be in repudiatory breach. However, the best way to try and avoid that would be to crystallize any position with respect to non-payment, because what will normally happen is you'll stop getting paid before insolvency happens. So although it's counterintuitive and although it might sound like a disputes lawyer trying to create work for himself, it's not. My view is you've got to be proactive at the moment if you stop getting paid on a job to protect yourself, because if you put a suspension of works or obligations notice out and suspend works before insolvency kicks in, then the SIGA Act wouldn't hit you. In terms of only relate to when an insolvency has happened, not before an insolvency has happened. So that was just one of the things that I wanted to flag up in relation to this slide, is that there is another act out there, the Construction Act, where there is quite a bit of tension, in my opinion, between this act and SIGA. So,
and before we move on to the next slide, I've just had another question that's come up in the chat. And if you can answer this or one of the other panel, what period of time does a party have to tell the other party, i.e. the company to the supplier, that they have entered an insolvency event? And Sadie Wallington's written this, and she said she's just trying to understand at what point any effects to the supplier commences from.
So from my perspective, the timeline will run as a matter of fact from the insolvency event happening rather than intimation of the event. Now the question is, what obligation does the party that's become insolvent have to tell you, and what timescale do they have to do that in? Either that will be in the contract, but there's no statutory obligation on notification here. So my view would be, certainly at the moment, if you were entering into a contract, you would put in a clause that mandated an obligation on a party to notify the other party to the contract that it had entered into an insolvency event, either in accordance with statute or in accordance with the contract, no later than however many days or hours you consider is appropriate. But there's no general legal principle and there's no general statutory obligation providing a time period within which notification needs to happen. but it will be the time of the event itself that will determine when insolvency happens rather than notification of it. That answers that.
Great.
Yeah, sorry, I've just seen a follow-up question. Yeah. So the follow-up question is: so the company would be in breach of payment terms. You could suspend if remedial time periods expire, but then you could find out they're in an insolvency event. Yes, in theory, yes, that's correct. It's in my experience, so that's theoretically possible. In my experience, cash flow generally dries up before, unless a sort of catastrophic event happens, which creates insolvency that happens overnight, particularly with bigger main contractors, which we've seen in recent years. And generally speaking, the money stops being paid whilst the company that is due the money frantically tries to stay alive and see if it can avoid insolvency. So you're right, you could in theory suspend and think that you've suspended before insolvency has happened, but you might find out that they actually have been subject to an insolvency event. That would certainly be mitigation. If court ever decides on this, the conflict between SIGA and the Construction Act, that would certainly be mitigation on the person serving the notice, saying, well, they didn't tell us, and we had no reasonable way of knowing at the time this was their first non-payment. It would be certainly mitigation against you being found to being in breach, and repudiatory breach in particular.
Justine, sorry, and Jonathan, yeah, and I agree completely, Jonathan. So I think the key to this, and we might sort of address it a bit later on, it's the timing of all of this. You know, has the supplier entered into the started to be a subject of an insolvency procedure? But I guess something to bear in mind is building in these things into your contract going forward, so that you are alerted or you can take action before this happens, or you're notified before they enter into the insolvency procedure, or you make sure you act sooner rather than later, so you're not caught by the SIGA, which is effectively, as soon as they're subject to an insolvency procedure, you're then prevented from taking these actions. Sorry, I just thought
Yeah, no, I totally agree. And what that would mean is, even if they didn't tell you, they'd be in breach of contract by not telling you, which again leads to the mitigating factor if there was ever any issue that issuing a notice of suspension was in breach of the CIGA.
Jonathan, you're on mute.
Next slide. But clearly, subject to the uncertainty, which I can't answer definitively because there is no definitive answer legally at present, clearly there are significant issues on a project. Well, there's significant issues in a project where one party to a contract becomes insolvent. There are significant issues to the party that is required to continue, in theory, to provide the supplies and services without any certainty that they will get paid for those. And there's not much, I would say, to be gained by the insolvent party insisting that works continue to happen, because that party will be at the very least in a restructuring or administration phase for a number of weeks without knowing whether or not the project in question is going to be continued by them or is going to be taken over by somebody that buys out in administration, or whether they go into liquidation. So it's really quite an unsatisfactory situation. But what you are going to have is essentially a supplier starved of cash, a supplier and a provider of services that's probably already on a tight cash flow margin. So everything that comes with that, in addition to the problems that your supply chain are having at the moment with delays due to COVID-related working practices, material supplies, from other countries, particularly the EU delays, Brexit, but also COVID-related supply delays due to lockdowns globally. There are going to be delays, risks of LEDs, and a lot of time that traditionally would not be, it would not exist in a project, but will exist now because of the circumstances that we're all living in. The issue about COVID-related delay will be, and is, unless the contract covers such delay off, for example, by it being a force majeure event, there's no remedy for COVID-related delay unless it's in the contract, subject to whether or not the employer or main contractor has created what's known as an act of prevention. So, for example, if the site needs to be configured or reconfigured in a certain way to allow COVID-related guidelines and working practices to be undertaken, and the main contractor and the employer doesn't put the site into such a condition, that would be an act of prevention to the subcontractor because it wouldn't be able to work safely in an environment in relation to the COVID regulations. That's not an insolvency point, but it's a delay point. And you've also got the issue of where do you stand as regard to collateral warranties, step-in rights and guarantees. This in-between moratorium area of insolvency is theoretically helpful to that company, but for a project it's highly problematic, and there will be question marks about all the tools and project management obligations and provisions that you put into the initial contract, whether or not they still have any value. And of course, obviously, there's limited recourse in the event of a dispute. Moving forward, if the employer or contractor is insolvent, that'll be down to the insolvency practitioner whether or not he wants to take any claims out against any other parties. If any other parties have been significantly impacted by the lack of cash from the insolvent employer or contractor, they're likely to be in trouble, and it becomes a situation of two people without money fighting each other to feed off the scraps, which I have seen happening quite a lot over the last 3 months. So I can now pass on to Nigel for the next slide.
There's a question that's come up in the chat box, and the question is, in our subcontract agreement, entering an adverse financial position is a breach, and hence something we could consider terminating the subcontract for. Do you think that would stand up if they hadn't gone insolvent, and would be at risk of would we be at risk of a repudiatory breach? PS, an express example of which is failing to pay its employees or suppliers on time. This is something I'm going to pick up on when I talk about pre-contract legal steps and drafting in contracts. And I mean, from my perspective, you can include what you want in your contract that you negotiate with the other side. And I don't think that if you were following the steps that were in your contract, that you would then be at risk of repudiatory breach. Jonathan, do you have anything to add to that?
I agree with that, absolutely. So as a matter of principle, adverse financial position, which includes not paying its employees or suppliers, is absolutely not necessarily an insolvency event. In fact, it's common practice in the industry, sadly. So I mean, obviously you'd have to check whether or not you have to give notice first for them to rectify that breach before you go straight to termination. So just make sure you follow the termination provisions in your contract. If something like that allows you to straight away go to terminate, then yeah, I agree with Justine. That wouldn't shouldn't make you fall for breach, subject to following the termination provisions of your contract.
Okay, right. Okay, on to Nigel, I think.
Right, okay. So I'm just going to share with you some of my things that I've done over the years and my experiences, but I'm sure NG Bailey will have very robust systems and processes in engagement, and probably lots of you will probably already know some of these things I'm going to tell you. So I hope I'm not going to send you to sleep. My apologies if I do. So yeah, from my experience, I mean, this is really an art rather than a science, really. But you know, it's gathering information, as much information as you can about your subcontractor before you actually start to engage them. And obviously, one of the key things is looking at credit reference agencies and getting credit reports on them, which will give you details of whether they've had any CCJs against them, their own subcontractor payment performances and that kind of thing. But you know, be mindful that quite often the data that you get from these sources is out of date. So you know, it can't always be totally relied upon. So I would always look to supplement that with management accounts. Ask for the latest set of management accounts just to see where the company is at this current point in time. And also look at the directors. You know, if you don't know much about the subcontractor, look at the directors and look at their other companies they've been directors of, and see if they've got a track record that shows that they've been directors of a number of failed companies. It's not a good sign to have directors that basically are in that position, frequently in that position. And obviously, as we all know, in the construction industry, cash is king. So how are they funded? You know, when you look at their accounts, do they have cash reserves? Are they feeding from hand to mouth? Valuation to valuation, or payments on other contracts being used to actually pay for progress on other contracts? You know, so how are they funded? Do they have loans, overdrafts? What kind of headroom have they got? And also, I would look at the past history of the company and its turnover, and the current turnover and its planned turnover. So if you talk to them and say, you know, what are you expecting to do this year? If they're looking to grow significantly, do they have the resources to actually deal with that? You know, are they being over ambitious? Are they overstretching themselves? And you know, and their financial resources, are they able to deal with what they're facing in the future? And what work do they currently have on site? And you know, and how much in your project, what percentage of their workload is your project in their workload, and how unusual would that make their workload? Is it you know, if you've got a contractor that's been around for quite a number of years and they always do a certain turnover, and they've got, you know, if you like, a steady resource of management, you know, that feels safer to me than a contractor that's actually starting to look a bit differently. You know, they're going to be slightly bigger or taking on more workload. So you know, be quite forensic in looking at where the company is going and what this project does to change their if you like, their current work patterns or their past work patterns. If you could go to the next slide, please. Thanks, Justine. And as always, you know, talk to previous clients and get references. That's by far the best thing to do. You know, and you know, what issues did other employers or contractors have with them? How did they deal with them? And you know, if you can get feedback from your subcontractor's own supply chain, that's really good. And you know, find out what you can on social media and articles and reports in the press. Obviously, being cautious as to its reliability. So if you could go to the next slide, please, Justine. And pre-contract practical steps. You know, if there is a parent, I would say always try to get a parent company guarantee. I mean, I've had a bad experience myself where a company that we didn't have a parent company guarantee, and a company that we were contracted with restructured and basically backed itself out of its post-contract liabilities. And there was a parent there. So, you know, you only do that once in your career, I think. So yeah, I would say always try to get some form of guarantee or the contract underwritten in some way, and ask for a bond. Well, it depends on the circumstances, but if you ask for a bond, if you feel it demands a bond, that's always a good sign, really, of the as a third party, i.e. the bondsman's going to look at the contractor and assess how good they are for credit, and the cost of the bond, I think, is also a good source of feedback as to how much that they are expected to pay to get a bond. And I know 10% is a standard bond, but I have actually procured 20% bonds in the past as well, where I've had a contractor that I've considered to be higher risk than I would like, and I've been very limited in my choices. Consider how the bond is released. Obviously, is it released at PC in whole, or do you release half of it and the rest at the end of the making good defects period? And ensure that the bond release date is an event, not rather than a definitive date, because obviously when you ask somebody to supply a bond, they quote you for it, and that will be based on a definitive time period, which would be the PC. But if the project is delayed by the contractor or subcontractor, there will be an additional cost for the bond to be extended, and you shouldn't be picking up that cost if they're responsible for the delay. So always ensure that the bond release date is actually an event like PC rather than the actual date of PC. And obviously be mindful that, as in the current marketplace, it may be difficult to get bonds. It's during the pandemic especially. And if it's a client, consider that how you get paid, whether you get your monies paid into an escrow account. So I think over to the next slide, Justine, which is not me.
That's me, thank you, Nigel. Back to me. So picking up on some points that have been mentioned earlier and things to consider when you're in the stage of drafting and negotiating the contract with your subcontractor. First of all, ensure that there is careful scrutiny of the contract sum analysis and the cash flow schedules to ensure that they're not heavy at the front end and therefore risk insufficient monies left to finish the job if the subby does become insolvent. So it's best to ensure that there are stage or milestone payments that are not front loaded, with the subcontractor receiving a greater portion of the overall subcontract over the overall subcontract sum during the early part of the works. Another is include retention provisions, either as a percentage of monthly payments or as a retention bond. Also ensure that the subcontract obliges the subcontractor to provide or procure full details of any of its subcontractors and suppliers that it intends to contract with, collateral warranties for those subcontractors with step-in rights, product warranties and guarantees. Ensure that if it has design liability, that it has adequate PI insurance in place and that you see evidence of cover. And also, if necessary, take vesting certificates in relation to any off-site materials. And also, it's a good idea to include drafting in the subcontract, which covers the points that I've made on the next couple of slides, and also picks up some of the points that Jonathan and I were mentioning earlier. So include a right to terminate immediately on an insolvency event occurring, but do bear in mind the impact of the SIG Act and the new processes, and consider making reference to those new processes in the contract. Also, as I said, include retention provisions, either a percentage of monthly payments or retention bond. A requirement that the subcontracts that the subcontractor enters into are assigned on an insolvency if insolvency occurs, including the balance of any retentions and further sums due under any other contracts. Also include a right of cross set off if you have other contracts in place with the subcontractor. Require that the subcontractor grants a lien over its plant and machinery and materials at the date that the insolvency occurs. Obviously, this might not be possible if the plant and machinery are leased. Appoint the main contractor as attorney and authorise it to carry out acts and execute documents as are necessary to render such rights effective within 7 days of any written request from the main contractor. Although this will probably be quite a difficult term to agree with a savvy subby. If you can get it in there, it's worth getting in there. Include an obligation that the subcontractor is obliged to issue an early warning as soon as it becomes aware of any matter adversely affecting the subcontract works or its performance. Now, obviously, it may not comply with that requirement, but having it in there will then assist with the next provisions that I'm going to refer to. So if the early warning is in there, coupled with requirements that the subcontractor has to provide certain information regarding its financial standing, if its credit rating falls below a required level, then it has to provide the following. Obviously, if you include drafting like this, it's sensible to monitor what's happening with the subcontractor's credit rating during the term of the contract. But what you could include in the contract is that it has to provide at a time that it's requested by the main contractor, its most recent management accounts demonstrating profitability and positive cash flow, a formal letter from a statutory director or member confirming the solvency of the organisation, and or a bank reference letter confirming that that particular bank considers that the subcontractor is an acceptable risk for a specified financial level. And then the contract would also need to require that the documentation must be provided, and if it's provided but it raises serious concerns, then at that point the main contractor can either omit work or ultimately terminate the subcontract. And as we said earlier, assuming you can negotiate those provisions and get them into the contract, and assuming you follow any contractual notice requirements, there's no reason why you shouldn't be able to terminate at that point, and it would not be considered a repudiatory breach of contract. Okay, I'm going to go move back to Nigel now, who's going to look at post-contract practical steps.
Justine, there's a question in the chat box. I'll read it out actually. Just, can a supplier claim on its insurance for a subcontractor insolvency, company insolvency, if all pre-checks are in place, evidenced, and the event could not have reasonably been foreseen? Or would this depend on the insurance policy? Can a supplier actually purchase insurance for third-party insolvency? I'll just start quickly. I'm not aware that you can take out insurance against third-party insolvency, but I suppose your insurance against the insolvency, if you've carried out pre-checks, or all these checks and balances that you can put in the contract. And also, one of the things you might want to think about is, Nigel touched on this from a employer versus contractor perspective in terms of guarantees and the like. You might, although an employer might refuse this, you might think about what sort of security you could claim from an employer if you're worried about it in terms of it going insolvent. So bonds, you might want to think about if you can get it, or you might want to think about project accounts or escrow accounts. So I think the types of insurance for this may be the things you put in your contract, and maybe the security you might set up. I don't know what the other panelists think. Maybe they can chip in.
Well, I agree with you on that. Is exactly what I would have said.
Yeah, no, I've got nothing to add. I'm not aware that you can take out insurance for supplier insolvency.
And if you could at the moment, it would be, the expense would just be ridiculous. With as with any insurance that involves construction at the moment, unfortunately.
Yeah.
Okay, shall I move on to slide 19 then? Post-contract practical steps. So really just looking out for warning signs, and it's not easy. Just keep an ear out for rumours. Rumours do start to fly around quite quickly regarding a subcontractor's financial position. If they're listed on the stock market, look for official announcements. You know, they need to notify their shareholders of significant changes in their organisation. Just make sure you're up to speed with that. And you know, is there any noticeable issues with regard to resourcing on the site? Do they, you know, is there a downturn in the amount of labour, plant and materials on site? Is the contractor starting to lose time? Is he going into culpable delay? Is there no apparent cause for it? Or they could all be signs of lack of cash. Or are there any personnel that have been removed from the project without any reasonable explanation? You know, where's Jack gone? He was here last week, and you don't really know. You know, so it's just there's no definite thing to say on this. It's just picking up nuances and actually looking at it and trying to interpret what you're seeing. And continue to undertake the credit checks on a regular basis. If you subscribe to Experian or Dun & Bradstreet, you know, you can get updates if there's any change in their position. But of course, they tend to be a little bit behind the time, and you don't really want to be reacting too slowly to these things. And try to foster an open door relationship with the workers on site, because they normally like to talk, and if they're having difficulty getting materials, you know, and resources to do the work, sometimes they'll give you clues that there's something going on. And if an insolvency does occur, you know, consider how key the people that are actually working on the site are, and what you need to do to try and not lose them to the project. You know, what's the value of their knowledge, and also at all times very, very careful valuation. Particularly if it's a situation where you pay in a subcontractor or contractor preliminaries, you know, just make sure that you're very aware of their actual progress, and that you're actually ensuring that you've always got enough money to finish the job if an insolvency event does occur. So over to the next slide.
Jonathan, I think that's you.
Next slide, 20.
Oh, sorry.
Yeah.
Sorry, is that you, Nigel, or Jonathan?
Yes, no,
Jonathan.
I've got it. Yeah. So yeah, again, this is where genuinely advice might be slightly different from what we'd normally advise, particularly at Spencer West, where we're very keen that disputes are avoided and wherever possible a pragmatic commercial approach is taken. However, we find ourselves in a position where slow action or delayed action may result in critical financial implications, and also critical delays and issues to the project. And much in tune with some of the things that Justine raised in our what about the contracts, early warnings, etc., and stuff like that. It's about being proactive at the moment, I'm afraid, and that may mean reaching for the adjudication format of resolving disputes sooner rather than later on a job. Now, it all depends on the job. It all depends on the other party to your contract, but you've got to take warning signs seriously at the moment that it may be an impending insolvency event, rather than just the normal sharp practice that you're used to. So there is no better time. I mean, this is one of the good things that's come out of the last 12 months, is that the industry has evolved. It's developed different practices, ways of working from home. I think digitalization has improved. But one of the things that we've always said, even pre-COVID, is records, and stay on top of your contract administration. And there is no better time and no more important time to make sure that that's at the core of your business, not just a particular contract. And together with that is having the right people on the job to spot a problem when it rises and dealing with it. And we're not people that encourage adjudications without due thought to the relationship and the project itself. But you really need to keep this at the forefront, otherwise you might find yourself really on the back foot when it comes to any issues that a subcontractor may suffer. So you're going to get, and I mean, I spent 6 years at TfL and Crossrail dealing every day with NEC contracts, which, despite their faults, and I'm not even going to pretend they're anywhere near perfect, at least it obliged the parties to work proactively and contemporaneously with issues that arose in the contract, and they just didn't do it. So we really need to throw that we'll just leave it to the end of the job and the final account will sort it out thinking on the back burner. And that also applies to making sure that both of you, the contractor and the subcontractor, comply with the contractual obligations, whether it's early warning notices, which are being ignored on at least 50% of the NEC contracts that I've dealt with, or trend notifications, or anything that's like an amber flag that there may be an issue. It needs to be followed. And if a subby turns around to you and says, "Oh, well, you're just being contractual, this isn't very collaborative," you're not being contractual. The contract is there for a reason. And what's the point in having it and spending not a huge amount of money on people like Justine, a very reasonable amount of money on people like Justine, but to make sure your contract's as tight as it can be if you're not going to follow it, and all the protections that it has, unless and until there's a dispute. It's got to be used proactively. And part of the tools that you have in your cash flow toolbox is adjudication. And they are, whilst broad brush and all the usual things that are said, one judge said, the Wild West of dispute resolution, they are an important tool in these times to maintain cash flow and or obligations under the contract, because of course you can get declarators if you're arguing over a term in the contract. That's critical to progress or critical to the payment process. You can get a declarative from adjudicator, which will be binding for the duration of the contract. So next slide takes us on to what happens after insolvency is confirmed. However that's confirmed, or ever you found that out, referring back to that question that was asked earlier. So you can find out various things, even if you're not told various things by the other party to the contract that's become insolvent. There will be an insolvency practitioner appointed, for example, and if as a result of the insolvency of any party that you're in contract with, claim arises, whether through contract or not, whether through there being defective works or not, you become a creditor in the insolvency process. So it's less concerning, or it's less concern to you at the time to continue contact with the other party, and more important that you get in touch with and notify your position to the insolvency practitioner who has been appointed in the insolvency process. So that's the first thing. Get your nose in and be known to whoever's dealing with the insolvency. You need to double check. You need to double check all the circumstances of the contract and the position of the other party to establish grounds for terminating, if there are any. The usual contract terms will apply. So if they've stopped working, there will be, well, first of all, that's a material or repudiatory breach of contract. But if they've been going slower and slower, which is also potentially a sign of cash flow problems, you've got the usual regularly and diligently clauses, certainly in JCT, that you need to keep an eye out on. There may be, depending on who the contract's with and what type of contract it is, and who's drafted the contract, there may be a termination at will provision, which would mean that you could terminate the contract for non-insolvency reasons. You've just chosen to terminate the contract. So there may be ways around all of this. When you look at the contract, you assess what's happened, you assess where you are in the process, and you see what options are available with you, for you. I mean, one of the things, again, it kind of chimes with what I said about being proactive and being contemporaneous and being on top of things. It's actually having a day-to-day ongoing relationship with anyone that you contract with at the moment, as far as you can. Trying to have as proactive and collaborative relationship as possible. I've heard, been in round tables recently, but I've heard two schools of thought. One where you've got project managers that are trying to go in and have the contractor, the client, and the subcontractors all get into a room, look at the supply chain, look at the program, look at where the critical path items are, flag up what issues there might already be known about, and then work our way through it as a team. And then I've had other people in round tables saying everyone's just gone back to type. People have just closed up. They're being commercial. They're not speaking. If you can get your relationship with everyone involved in the project as collaborative as possible, and then in as virtual a room or site office as possible, then that can only help. You've got potential statutory assistance if a party has been defective through the Third Rights Act, if that's applicable, or Defective Premises Work Act, if that's applicable as well. But really, you want to, at that sort of stage in the process, you really want to have avoided being surprised by this, because you've dealt with your contract and your relationship with the other key parties to your project in a collaborative way, and that really is key. Whether you're working to NEC, which promotes it, or JCT, which has started to try and promote it, doesn't matter really. Their behaviours and actions, human behaviours and actions don't need to be contractual. They can be driven by the people that run the project. That's been done for that one. I think that's you, Justin.
Okay, I'm aware we've gone a little bit over time, so I'm just going to try and wrap up very quickly in a couple of minutes. And I want to just look at what to do if the insolvency's occurred, in terms of gathering information from the subcontractor. So first of all, obviously get hold of all relevant contract documents relating to the subcontract, including things such as your payment applications and notices, copies of any subcontracts if you don't have them, insurance policies from the subcontractor, particularly if it's got design responsibility and has PI insurance, and also product liability, and also guarantees. Make sure that you have copies of all of those if you don't already have them. Also vesting certificates regarding materials off site. And again, if the subcontractor has design responsibility, ensure you have up-to-date copies of all drawings and any other copyrighted documentation and licenses. Make sure the site's secured. There may be other subcontractors further down the supply chain that have not been paid as well, and might want to try and remove materials and equipment from site, but you want to ensure that they're all kept on site. Consider whether at this point, depending on where you are in the project, if you need to replace the subcontractor to complete the works, and obviously you may need to act quickly to avoid the risk of the main contract, your contract works getting into delay, particularly if there's concern around LD, liquidated damages, being levied. It's also important to record the condition of the site, ideally by an independent professional, including the value of the completed works executed up to the date that the insolvency happened, including variations. Also, ensure you have a note of all the goods and materials on site and a record of any defective works. This will be particularly important if you do need to engage a new subcontractor, because you don't want to get into a dispute with the new subcontractor regarding the existing of the site when they take over. Consider whether or not you need to obtain any goods or materials which are located off-site, which have been paid for already. Most construction contracts provide for payments to the subcontractor to stop upon its insolvency. Obviously, be mindful of having to serve any pay less notices. The contractor will need to keep a full account of the payments made to the subcontractor to date, and this comes back to obviously keeping your records up to date. And a detailed account of the costs for completing the works, and then a final account will need to be prepared. If there are any bonds or guarantees in place, if there's a parent company guarantee, have a look at it, make sure, see whether or not it covers the present situation. Is the parent itself in an insolvency situation, or is it possible to enforce the guarantee? Is there a performance bond? Has the subcontractor procured the performance bond in the main contractor's favour? And consider whether or not, look at the wording and see whether or not you can make a call upon the bond in the event of the subcontractor insolvency. If you can, make sure that you comply with the requirements in the bond in relation to making such a call. What about any collateral warranties and step-in rights? Check that you have copies of all subcontractor collateral warranties that the subcontractor was required to obtain under the subcontract in favour of the contractor. Alternatively, if there were third-party right notices, make sure those are served at the relevant time. And it's obviously important to get hold of those subcontractor warranties, particularly if it concerns subcontractors with design obligations, so that if necessary, you can rely upon those subcontractor warranties in the event of any defects in the works. And then finally, consider any step-in rights under the subcontractor warranties. So does it allow the main contractor to step into the shoes of the subcontractor and take over the contract with the subcontractor? Okay, I think that comes to the end of our seminar today. I think that's everything that we were intending to discuss. Are there any other questions from anyone in the audience today? As I said, if you have any questions after the event, then I'm just going to pop up our details. Obviously, Scott and Kenzie have all of these details as well. So either direct them to Scott or Kenzie and they can pass them on to us, or message us directly. We'd be really happy to help. Okay, I don't know if I've got any other comments from the panellists, or that's it today. Okay, well, I hope that you have found it useful, and yeah, as I said, if you have any questions, then do please follow up with any of us. Thank you very much.
Thank you.
Thank you.
Thank you, Justine.
Close this down then. Thanks a lot. Bye.
Sometimes